Hi, I'm going to talk to you now about innovation law and strategy. I'm a technology lawyer and I specialize in innovation management with a focus on R&D and technology commercialization. In this short clip, I would like to share with you how I would deal with innovation law issues from the business as well as the R&D management perspective. The role of lawyers in managing innovation is to help the customer or the client create value and avoid strategic risk. Typically, in dealing with any innovation project, there are 4 stages. First is the creation of the intellectual capital or the innovation itself. Second is the protection of your fruits of innovation. The third is management of your innovation asset, including portfolio management, raising of financing, ensuring that what you create doesn't leave the organization illegally. Then lastly, exploitation or commercialization. I call this the CPME ecosystem. Create, protect, manage, and exploit. I now would like to share with you the fundamentals of intellectual property. Intellectual property deals with the fruits of innovation, which is a result of the exercise of the human intellect. Intellectual property is a legal right that captures and protects in a codified form a set of legally recognized rights. Let me give you an example. This is my BlackBerry. The shape of the BlackBerry itself can be protected by way of design right. The software that runs it is protected by the laws of copyright. The software itself can also be patented. Business method can also be patented in many jurisdictions. Next, you can also have trade secret. Say, for example, the methodology or the processes that is embedded in this is protected as a corporate trade secret. That is also regarded as a type of intellectual property. So in a typical technology innovation such as this, one has to understand the risk that the creator or the innovator faces. The first primary risk obviously would be the risk to the intellectual capital, or specifically the intellectual property right. So the role of a lawyer in managing the innovation ecosystem is to try to ensure that the value that the innovator have created is protected, it is managed properly, and it is exploited in a way that would extend to the fullest extent possible allowed by the law, the economic value of the asset. So to recap, the role of lawyer in managing the innovation cycle is to avoid strategic risk, which will include violation of the intellectual property right. But even more importantly, the role of the lawyer is to help extract commercial value of the innovation, and this is typically done by way of licensing. I hope in this 5 minutes I've given you a flavor in terms of how a lawyer should manage the innovation cycle, fundamentally focusing on strategic value creation issues as well as the avoidance of risk issues. Thank you very much.